Welcome to The Explainer. Today, we're diving into a fascinating, high-stakes legal dispute that actually took place at one of South Africa's most famous tourist spots, the Victoria and Alfred Waterfront in Cape Town. Picture this. You've got a grounded helicopter, a landlord demanding total compliance, a tenant flat-out refusing to back down, and a legal battle that escalated all the way to the Constitutional Court of South Africa. It's absolutely a story about aviation rules, but more importantly, it is a masterclass in what happens when private contracts collide with public administrative law. Let's get into it. Here's our roadmap for The Explainer today. We'll start with the grounded helicopter dispute, then move into the lower court battles, figure out what a collateral attack actually is, unpack the Utica precedent, and finally, look at the Constitutional Court's final ruling.
All right, let's jump right into part one, the grounded helicopter dispute.
So, the setup here is actually pretty straightforward. You've got your landlord, the V&A Waterfront Properties, and you've got your tenant, Helicopters and Marine Services, who were operating alongside the Huey Extreme Club. They leased a helicopter landing site right there at the waterfront. Now, we also have a third super important party in the mix, the Civil Aviation Authority, or the CAA, who are the folks responsible for aviation safety. But here is the absolutely crucial detail. When the tenants signed the lease to use this helipad, they made a very specific, ironclad promise to the landlord. They explicitly undertook to comply with all the rules and regulations of the CAA. Keep that promise in the back of your mind because it is literally the pivot point for this entire case.
So, how does a simple lease turn into a massive legal showdown? Let's look at the timeline. After the lease is signed, everything is presumably fine, until January 2004. That's when the CAA steps in. They issue a formal order grounding the helicopter, stating it absolutely cannot fly until their inspectors can make a proper assessment of its airworthiness. Now, you'd think the helicopter would just stay safely on the ground, right? Well, by early February, the landlord starts to panic, fearing the tenant was just going to ignore the grounding order and fly anyway, which, as you can imagine, would put the landlord in a terrible legal position. The V&A Waterfront launches an urgent application in court. They wanted an interdict, basically a restraining order, to stop the tenant from flying in breach of the lease and the CAA's rules.
Which brings us to Section 2, the lower court battles.
This is where we really see the friction in the legal system on full display. The V&A Waterfront goes to the Cape High Court, essentially saying, please stop this helicopter from flying. But the Cape High Court actually dismisses the landlord's application. They side with the tenant in round one. But the landlord doesn't just walk away. They appeal that decision up to the Supreme Court of Appeal, or the SCA. The SCA looks at the exact same set of facts, completely overturns the Cape High Court, and grants a final interdict in favor of the landlord, officially grounding the chopper. Talk about legal whiplash. That sharp disagreement between the two lower courts is exactly what pushed this case all the way up to the Constitutional Court. But hang on a second. We really have to pause and ask, why on earth did the tenant think they could just ignore a formal grounding order from the aviation authorities? I mean, that sounds incredibly risky, right? To understand their strategy, we need to unpack the complex administrative law they were using for their defense. And that brings us to Section 3, understanding collateral attack. So what exactly is a collateral attack? Basically, it's a defensive shield. It happens when someone ignores an administrative act, like, say, a grounding order, because they believe that act is legally flawed or unlawful. Instead of going to a judge first to get the order officially canceled, they just pretend it doesn't exist. Then, when a public authority comes after them to punish them for ignoring it, they raise this collateral attack shield. They argue, hey, you can't punish me because your original order was invalid anyway. And the tenant in our case, they were trying to use this exact same shield. They argued the CAA's grounding order was flawed, so they could ignore it, and therefore the landlord couldn't use it against them.
Which leads us to Section 4, the Utica precedent.
When the Supreme Court of Appeal ruled against the tenant, they leaned heavily on a famous case called Utica Estates versus City of Cape Town. Now, the actual quote from the ruling is a bit dense. It says, if the validity of consequent acts is dependent on no more than the factual existence of the initial act, then the consequent act will have legal effect. Okay, let me be your translator for a second. What does that actually mean in plain English? It means that sometimes an administrative order, even if it has legal flaws, still physically, legally exists in the real world. And if a subsequent action, like a landlord enforcing a lease, relies purely on the mere fact that the order exists, rather than the order being absolutely legally perfect, well, then that subsequent action is totally valid. Basically, the order exists until a court formally says it doesn't. Now, this Utica precedent is absolutely crucial. Why?
because it sets a strict boundary on when you can actually use this collateral attack shield. It's generally intended for situations where a public authority, like the government, the police, or a regulatory board, is directly trying to coerce you into complying with an unlawful act. It's designed to protect everyday citizens from direct government overreach, making sure the state can't force you to obey a broken law.
Let's put these two scenarios side by side to see the exact distinction the court was grappling with here. On one hand, you have a classic public law dispute. That's a citizen directly fighting unlawful coercion from the government. That is the traditional home of the collateral attack. But on the other hand, you've got a private contract dispute, which is literally just a landlord holding a tenant to a piece of paper they signed. The Constitutional Court had to decide, does a private landlord enforcing a lease count as public coercion? And this exact question leads us right into Section 5, the final constitutional ruling. So, the case hits the Constitutional Court, and they systematically dismantle the tenant's arguments. First, the tenant tried to say that the CAA was basically using the landlord as a puppet to indirectly enforce the grounding order. The court firmly said, nope, rejecting that completely. They ruled this is purely a matter of enforcing a private contract. The landlord is just acting like a landlord. Next, the tenant argued they should be allowed to use their collateral attack defense against the CAA's order within this landlord dispute. The court rejected this too. They stated that even if they wanted to broaden the rules of collateral attack, it just wouldn't be right to extend them to cover a private lease agreement. The absolute bottom line from the Constitutional Court really came down to this quote, once there is a grounding order in existence, the landlord is entitled to rely on its mere factual existence. It really is that simple. The V&A Waterfront didn't have to prove the CAA's inspection protocols were legally flawless. They didn't need to defend the CAA at all. They only had to prove one undeniable fact. A grounding order existed. Because the lease explicitly said the tenant had to follow CAA rules, the mere physical existence of that document was enough to trigger a contractual breach. So what should the tenant have done instead of just crossing their arms and playing the collateral attack card? The court laid it out in 3 easy steps. Step 1, formally challenge the CAA order in a competent court. Step 2, have the grounding order legally set aside by a judge. And then, Step 3, resume flying the helicopter legally. And get this, the court explicitly noted that the tenant had actually done this successfully with the previous order. They knew exactly how to fight the cow properly in court. But for some reason, this time around, they chose to just ignore it and rely on a flawed defense strategy. So what are the big takeaways from this explainer? First off, private contracts and the promises you make in them are binding, period. If you promise someone you'll follow public rules, they can and will hold you to that. Second, you can't just ignore an administrative order simply because you think it's invalid. It exists until a court formally says it doesn't. Third, the mere factual existence of a regulatory order is absolutely enough to trigger your obligations under a private contract. Ultimately, because the tenant's case had no real prospects of success, the Constitutional Court dismissed their appeal and ordered them to pay the legal costs. A tough lesson, for sure. It's a truly powerful lesson in how the law operates in the real world. You just can't use a public law defense to wriggle out of a private contract. So I want to leave you with this final thought. Next time you or your business face an administrative hurdle that you think is totally unfair or legally flawed, will you risk ignoring it and hiding behind a collateral attack? Or will you take the proper route and tackle the order head-on in court? Thanks for joining me for this explainer, and I hope this gives you a much clearer understanding of how these complex legal forces actually interact out there in the real world.